Well, I think we'll start. I hope everyone can hear. A warm welcome to this, which is the fifth and final event in this mini-series hosted by Brick Court Chambers and dealing with litigating abuse of dominance cases. So far, we've covered quite a lot of subjects, including developments in substantive law, abuses and pharmaceuticals, litigating big tech and data abuses. And then the fourth one last week was interim injunctions. And so logically, this final webinar touches on the very important subject of regulatory appeals. Perhaps I can just say, before launching into any kind of introduction, that a technical matter, if you have any questions that you wish to put to the panel, then you should have a question box somewhere on your screen. And if you type your question into it, it will be recorded and sent through to me, and if all works as it should do. And then I'll be able to put it to the panel. I hope we'll leave some time at the end for those questions. I will introduce each of our very distinguished speakers just before they talk. But before doing so, perhaps I should just set the scene for a moment. Clearly, on this subject, regulatory appeals, the Competition Appeal Tribunal is at the heart of the subject. Many of you who are listening will be very familiar with the CAT, as it's known. But in case some of you aren't as familiar, perhaps I should just point out one or two salient features of the system, and in particular of the CAT. It's an independent specialist expert tribunal, small in terms of the number of permanent judges, which really amounts to one, namely its president. But it does, of course, have access to judges in the form of chairman of the panels who sit on cases, who are either very experienced and expert lawyers in competition and regulation law, or are High Court judges who were also similarly experienced. And they, the chairman, lawyer chairman, sits with hugely eminent wing members, as they're sometimes called, who are either distinguished economists, for example, or industry experts. So it is for that reason, it is a very expert tribunal. The Court of Appeal, for that reason, has very recently, emphasised that a good degree of deference should be afforded to it when the Court of Appeal hears appeals from it. And that appeal courts should be slow to question the findings and conclusions of the CAT, and should, on the basis that, given its experience and expertise, it is, in all probability, has got the matter right. But of course, today's subject is dealing more with appeals to, I suspect, the CAT, although I think there may be that the standard of review that some of the speakers are going to touch upon will also mention the standard of review on appeals from the CAT. Perhaps I should also just say that we are only dealing with a very one part of the CAT's jurisdiction, a very important part, a crucial part indeed, for the effective and fair operating of the competition and regulatory system. But one perhaps should also remember that the CAT has an ever-increasing workload in civil claims, private law claims for damages, not least the burgeoning collective action claims that have really resulted from the expansion of the CAT's jurisdiction over collective claims in the Consumer Rights Act of 2015. As far as the regulatory appeals are concerned, they are essentially twofold. There are two main categories. There are the appeals in competition cases, enforcement cases, where the regulators have found an infringement of the competition rules and may well have imposed fines on the guilty party. And secondly, there are appeals from Ofcom's decisions in telecom cases. And the standard of review is slightly different in the two categories on appeals. The communications cases since 2017 have operated an enhanced judicial review test of appeal. And one can perhaps understand why that should be the case, given that these are not decisions which impose quasi-criminal sanctions. On the other hand, the competition cases operate as an appeal on the merits, where the tribunal does have a wider remit to investigate the facts and the law, by reference, of course, always to the notice of appeal. And I'm sure it will be emphasized that the appeal on the merits is not a rehearing of the administrative procedure. It is an appeal by reference to grounds of appeal. It's an appeal against the decision, the administrative decision. So that is the starting point, and the appellant must indicate really that something has gone wrong with the decision in order to succeed. Well, there have been a number of recent reviews and changes to the system. I mentioned one, the expansion of the CAT's jurisdiction in 2015 in civil claims. But there's always a review going on. And we saw there was the Furman review in 2017. There's very recently been a review known as the Penrose Report, which has made a number of recommendations. And a lot of these stem from the fact that we are undoubtedly, competition and regulatory cases have become extremely complex, and both in legal terms and in economic terms, and in the interface between the two, in the context often of very highly technical subjects. The first speaker is Hugo Leith. He is a star junior from Brickcourt Chambers. He's no stranger to the Competition Appeal Tribunal. In his directory comments, he's described as user-friendly and practical. He doesn't just give the textbook answer, but instead offers a practical solution. Hugo practices in competition law and in regulatory, damages, and public law cases, appearing for claimants, defendants, and regulators, including in the interchange fee litigation and in various cartel damage claims. And today, Hugo is going to kick off by talking about the all-important subject of the standard of review in appeals. So Hugo, I hope you have been able to hear this. Over to you, if you have.
Thank you, Gerald. Yes, I heard that. Thank you for that kind introduction. So I will be talking about some aspects of the standard of review applied by the Tribunal to decisions of the CMA, and to address the particular kinds of points that may provide the basis for an appeal, and some of the specific points that come up when the Tribunal is exercising that particular jurisdiction. So there are several strands of principle that I'll be going through which pull in different directions. And so in the short time available, what I propose to do is just look at some of these in turn, and then afterwards just briefly show how these may play out on specific issues. It's necessarily quite an incomplete picture, but what we might see, or hopefully can observe, is that there can be an interaction between the rules on the standard of review and the rules as to the procedure that has to be observed, and the way that the substantive legal rules on abuse of dominance are actually applied. In particular, I'll be looking at the field of excessive and unfair pricing. And so, to put it another way, the question is whether the procedural rules and the rules on the standard of review can have some effect on the consideration of the substantive legal rules, whether they have some substantive legal effect as well. Now, the starting point, as Gerald mentioned, is that the jurisdiction of the Tribunal hearing an appeal from a decision in this field is not to conduct a de novo hearing into the question of whether there's been a breach of the competition rules, whether there's been an abuse of dominance in this sphere. Rather, the Tribunal hears appeals against the decision of the CMA, and this stems initially from the statute under Section 46 of the Competition Act. It's provided that a party whose conduct is the subject of a CMA decision may appeal, quote, against or with respect to, unquote, that decision. And so what that means is that the focus of any appeal to the Tribunal is on the decision under challenge, or as it's been put, the decision is really the focus, it's the start, middle, and end point of the appeal in the Tribunal. So some years ago, the Court of Appeal in T-Mobile and Ofcom explained that the role of the Tribunal is accordingly quite circumscribed. It said, the way it put it, was that what it is called for is an appeal body and no more, a body which can look into whether the regulator had got something material wrong, and it decried the possibility, or warned against the possibility, of the Tribunal acting as a substitute competition authority waiting in the wings. So it was approaching, the Court of Appeal in T-Mobile there was approaching the question as to the extent of the review that had to be observed, in particular under Article 4, and it emphasises the role of a review, essentially, of the decision below. This approach is then also reflected in the Competition Appeal Tribunal rules, which I think, as Gerald mentioned, require an appellant challenging a CMA decision to identify specific grounds challenging the decision itself. And so in Rule 9, we see that the notice of appeal must include a summary of grounds for contesting the decision, identifying various matters, including whether it said the decision was based on an error of fact or was wrong in law, or whether there's a challenge to an exercise of discretion in making the disputed decision. And so, taking all these points together, it's not a de novo jurisdiction, but really one that's focus is on the decision. So that's the first kind of point of principle. The second point of principle, though, is that as Gerald mentioned, the CAT is nevertheless still exercising a merits jurisdiction. So while appeals are not de novo, the Tribunal's jurisdiction is also more extensive than exercising, for example, the powers of the Administrative Court. On a judicial review, it's often described as a merits jurisdiction. And so, for example, the Tribunal in Hutchison 3G and Ofcom explained that, unlike in a judicial review, the function of the Tribunal is not concerned solely with whether a decision is adequately reasoned, but also whether those reasons are actually correct. Now, there's a complex underpinning to this aspect of the jurisdiction, which stems from the characterisation of the CMA's powers to impose fines for an infringement as an aspect of criminal law. Because the power to impose fines belongs to the sphere of criminal law, the case law provides that Article 6 imposes minimum and extensive standards of review of those decisions. And so, for example, the Court of Justice in Schindler and the Commission explained that decisions taken by administrative authorities which do not themselves satisfy the requirements laid down in Article 6 of the Convention must be subject to subsequent review by a judicial body that has full jurisdiction. And the characteristics of such a body include the power to quash in all respects on questions of fact and law the decision of the body below, and the judicial body must in particular have jurisdiction to examine all questions of fact and law relevant to the dispute before it. And so in the context of the CMA, because the CMA itself doesn't have the characteristics that meet the requirements of Article 6 itself, while it does have other extensive duties as a public body, it doesn't meet that particular definition under the Convention. That task then falls to the Tribunal necessarily in order that there's a complete regime in place for the review on a full merits basis of the Tribunal of the CMA's decision by the Tribunal. So it follows that the Tribunal has power and indeed a duty to hear evidence and to allow that evidence to be challenged and through cross-examination and so on. There's a further point that then also follows from the characterisation of the Competition Authority's powers as criminal, which is that as the Tribunal explained in NAP, the Competition Authority will bear the burden of proof throughout the proceedings. And moreover, as the Competition Markets Authority is a public body, it will also have various duties of good administration, which the Tribunal can then enforce in the context of an appeal. So they're more in the sphere of procedural grounds for review that may complement an appeal on questions of substantive law or a challenge to the exercise of discretion and so on. So just pausing there, we've seen that the review is not de novo; it must challenge the decision. The focus is on the decision, but then in turn there is a full range of merits review that the Tribunal must exercise while holding the Competition Authority to discharging the burden of proof. So moving on from there to a third principle, which is whether the CMA has a margin of appreciation or discretion or a margin of manoeuvre. Now, in general, so just not just confined to the areas of abuse of dominance, the Tribunal has recognised that there are instances in which there may not be a single right answer to a particular question. So, for example, in a series of cases, including Albion Water, the Tribunal has recognised that if the regulator has adopted what's been described as an appropriate and reliable methodology, the Tribunal may be slow to interfere, even if there have been other methodologies which an aggrieved party could have proposed. So that's the kind of general position which is observed across the appellate jurisdiction. This is particularly the case where the regulator is called on to exercise policy judgments, that there'd be this hesitancy or deference given to interfere with a judgment that the CMA has made on an appeal where there's an issue of policy that arises and where the underlying approach that's been taken is generally thought to be reasonable or appropriate and reliable. Now, in addition, in the sphere of unfair pricing under abuse of dominance, there's a further aspect or side to this margin of appreciation or margin of discretion, which is recognised in the case law of the Court of Justice. It's said that in this case law, including in particular in the Latvian copyright case, that the competition regulator has a margin of manoeuvre in developing its framework of analysis. In Latvian copyright, the Court of Justice said it falls to the competition authority concerned to make the comparison and to define its framework although it should be borne in mind that the authority has a certain margin of manoeuvre and that there is no single adequate method. So this idea of a margin of discretion is pregnant with uncertainty, and in turn raises further questions as to how that margin is itself to be limited, if at all, and indeed if the tribunal does overrule the margin of discretion or manoeuvre, whether that in turn should be given further deference on further appeals, given that the tribunal is in turn a specialist body. It's in the Pheneton litigation, the Court of Appeal, in the form of Lord Justice Green's judgment, held that the tribunal is not bound to defer to judgment calls of the competition authority, and emphasised that the existence of a margin of discretion does not dispense with the requirement for an in-depth review of the law and of the facts by the supervising judicial body. So, just drawing some of these threads together, the tribunal does not exercise a de novo jurisdiction. Rather, it considers whether the tribunal has erred, and the focus is rather it considers whether the CMA has erred, and the focus is on the CMA's decision. But at the same time, the tribunal exercises a merits jurisdiction, which includes hearing evidence. The competition authority bears the burden of proof, but further questions may then arise as to how heavy that burden is and what the obligations of the authority are in discharging its duty of good administration. Finally, the competition authority has a margin of manoeuvre both generally and in unfair pricing cases. The tribunal is not bound to defer to all exercises of discretion by the authority. So, sort of setting the scene, giving that framework, there's just like to explore how these various aspects of the standard of review and the particular grounds of review that arise in the context of an appeal before the tribunal can be applied in practice, and how they can relate to and influence the questions of substantive law that may be applied. And take as an example the case law on unfair pricing. In cases on unfair pricing, a recurring question in the case law and in the academic literature has been as to how a price is assessed as unfair or otherwise. And this question has in part arisen from the wording of the Court of Justice's reasons in the United Brands case. And just to recap on that, the court stated that a price would be abusive if it was first excessive, and second, if it was unfair in itself or by reference to competing products. It's a very short passage of reasoning in United Brands, but one that's given rise to a great deal of commentary and dispute in litigation on that second limb, which I'll just repeat again, which is whether the price is unfair in itself or by reference to competing products. The question that has arisen as to whether the two methods of proof mentioned by the Court of Justice in United Brands are actually alternatives. So that this is a question that's arisen as, for example, could a competition authority establish that a price is unfair simply by finding that it is unfair in itself? Or would the competition authority also have to consider whether it is unfair by reference to competing products also? Other questions include, for example, if a competition authority looked at one form of proof to reach a conclusion on this limb, but there was evidence on the other form of proof that may point to a different outcome, what's the right approach to be taken? What would the competition authority have to do? And what would the tribunal have to do? Now, issues of this kind were canvassed in the Pfizer-Flynn appeals. These were appeals brought before the tribunal against the decision of the CMA, finding the pricing of two pharmaceuticals firms, Pfizer and Flynn, for a product used to treat epilepsy was abusive and imposing fines. Pfizer and Flynn sought to rely on the pricing of other products used to treat epilepsy as indicating that their pricing was not abusive. Now, it's a vast case with a lot going on, but just to give you the potted summary, the tribunal set aside part of the CMA's decision, and then there was a further appeal to the Court of Appeal, and in which there are two judgments given by Lord Justice Green and Chancellor Voss, as he then was, which in part allowed the CMA's appeal and made some other comments on the appropriate test. Now, there's a great deal in the judgments which is beyond the scope of this short talk, but I would just focus on one part of the reasoning in which some of the points on the nature of and limits on the review by the tribunal, which we've discussed earlier, do feature and perhaps influence what the Court of Appeal said as to the correct approach for the tribunal to take on substantive questions of law. So, starting with the margin of discretion or the margin of manoeuvre, Lord Justice Green observed that the fact that this margin exists means that a competition authority is not obliged to use in its own analysis both limbs of the unfair test. He said that, I mean, there were for various other reasons, but including this reason, it wouldn't be necessary for the competition authority for it to satisfy itself to the full, through a full investigation, that both limbs of the test for unfairness were met. But at the same time, he also said that the competition authority could not ignore relevant evidence that was advanced by an undertaking. And Chancellor Voss likewise said that because of the CMA's duty of good administration, it had a duty to consider prima facie evidence on comparator products put forward by the undertaking under investigation. So these aspects of, if you like, the qualified degree of deference that the tribunal and other courts would give to the CMA, that the margin of discretion that it has as a competition authority has an influence on the way that the substantive question posed by the Court of Justice in United Brands, it has some influence on the application of that test. So one other point that's mentioned in the reasoning is the question of a full merits review. The question that arose was whether, because the tribunal does conduct a full merits review, as we've seen, in which the undertakings, who are the appellants, can put forward evidence, whether this reduces in any way the burden of investigation that the competition authority has to undertake into other methods of proof that it itself has not placed primary reliance on. So the theory being that because all of these questions will be determined on and considered and ventilated on appeal, whether that means that the degree to which the CMA itself has to investigate these matters at the administrative stage is reduced or modified in any way. Lord Justice Green said that the nature of the merits jurisdiction did not affect the scope of the duty of the competition authority at the first stage, at the administrative stage. And this was for various reasons, including the fact that a decision once adopted had quasi-criminal consequences and that the undertaking has the presumption of innocence. But he did then say that the authority in carrying out its investigation does have a margin of discretion or manoeuvre in how it goes about it. And Chancellor Voss similarly explained that the CMA has a margin of appreciation in deciding how to discharge its burden of proof in this administrative stage. So perhaps just drawing this together, the point of interest is that the Court of Appeal here did refer to aspects of the standards applied by the tribunal on a review and aspects of procedure when interpreting how the substantive underlying question of law is to be approached in practice. And so it'd be interesting to see if in other contexts similar links can be drawn between the more procedural side and the underlying substantive questions of law. And that's where I'd leave things.
Hugo, thank you very much indeed. You covered a huge amount of territory in a short time, and helped us with that important and recent case law. I've left my camera off at the moment because of the warning on my screen, but that I'm sure is no loss to anyone. So I'm going to go straight away to Daniel, who's going to speak now. Daniel is also at Brick Court Chambers. He's a competition law specialist with a background in economics. Since he transferred to the bar from a Golden Circle law firm in 2010, he's worked on many high-profile abuse of dominance cases, both here in the UK and also in the EU. He's acted for Intel and for Google in the General Court, and for the CMA in the paroxetine appeal in the CAT. And he's acted for both complainants and defendants in several UK abuse of dominance investigations in both regulated and unregulated sectors. Today, he's going to talk about the dividing line between issues of law and economic assessment in the context of exclusionary pricing. So without more ado, over to you, Daniel.
Thank you, Gerald. So yes, I'm going to be talking today about that dividing line between points of law and points of economic assessment. And that distinction is important for two reasons, really. Firstly, it's important when you're appealing a decision of the Competition Appeal Tribunal up to the Court of Appeal or further to the Supreme Court, because issues of law can be taken up to those courts, but issues of assessment uniquely for the original decision maker and then the Competition Appeal Tribunal. But beyond that sort of jurisdictional question of second appeals, the distinction between points of law and points of economic or factual assessment also has wider implications for legal certainty, as I'll come to shortly. And so I'm going to be exploring that question, that dividing line, by reference to the Court of Appeal's decision from just last week in the Royal Mail case. And the way I'm going to do that is firstly to explain what that case was about. In other words, what Royal Mail did. Then I'm going to talk a little bit about the key issue on appeal in that case and how the Court of Appeal dealt with it. And then I'm going to take stock of where that has left us in terms of appealing from decisions of this kind, which concern exclusionary pricing. So the facts of this case were really quite stark, which is often a bad start for developing the law in this sort of area. It was about the delivery of bulk mail. And by bulk mail, we mean high volume mailings, things like bank statements or utility bills or advertisements that just get shot out to large numbers of people around the country. And the way that market has worked since deregulation is that there are these competitors called access operators, like Whistle, and they compete with Royal Mail to win the business of the banks or the utilities or the advertisers. And then, rather than actually delivering those letters to us all themselves, they pay Royal Mail in the wholesale market to do that last leg, the actual bit of delivery to individual addresses. And then, in terms of the question how much they have to pay to Royal Mail, well, Royal Mail offers a suite of different access terms to those access operators, depending essentially on the geographic spread of their businesses. So if they match Royal Mail's geographic spread more or less exactly, then they get one set of prices. If they don't, or if they focus on just one zone, for example, then they might pay a different price. So that was sort of the way things were bubbling along before the facts of this case got started. Then what happened was in 2012, Whistle, who was one of these competitors, became a bit more ambitious. They actually wanted to launch an end-to-end service where they would not just contract with the banks or utilities, but then they would go further and actually deliver the mail to individual addresses. They couldn't do that on a nationwide basis, at least not in one go, but they could target particular areas and then rely on Royal Mail to do the rest on the access terms. Now, Royal Mail didn't like that, and up to this point in the story, it's a fairly familiar tale. Royal Mail is concerned that what's going to happen is that Whistle and others like it will cherry pick the parts of the business that are most profitable. And because the access terms are based on geographic averages, if the downstream competitors cherry pick the profitable bits and they leave Royal Mail to do the rest of it, then Royal Mail is going to be in some trouble. So Royal Mail didn't just sit back and take it. They responded by proposing to change their access prices to create a differential between one of the national pricing plans and another national pricing plan that they had. And the details don't matter for our purposes, but the basic idea was that if Whistle had its own end-to-end service, it would not meet the requirements for the first plan. And so it would have to pay the higher prices associated with the second plan on the parts that it still needed to rely on Royal Mail for. And so Ofcom and the CAT found that the whole point of this change to the access terms that Royal Mail had made was to deter competition from Whistle. And they also found that it worked spectacularly well. So although the proposal actually never came into effect, and so nobody ever paid these new prices at all, the mere announcement of the prices was enough to make Whistle suspend its efforts to enter the market and eventually to give up entirely. So what happened next? Well, after a 4.5-year investigation, Ofcom concluded that this was an abuse of Royal Mail's dominant position and imposed a fine of £50 million. And just as an aside, before I get into the issues, I just note that this case is a really nice illustration of the speed of the UK competition appeals system. The conduct itself lasted for just over a month. The investigation then took 4.5 years, which is the longest single piece of it. The Competition Appeal Tribunal then produced a judgment just 15 months later. And then the Court of Appeal produced its judgment just 18 months later and just 2 weeks after the hearing. And I just note that because the CMA and or some people at the CMA and some politicians from time to time have complained that the merits review system that we have in the UK is too slow. But I think this case is quite a striking one of speed, and particularly at the appeal stage, the Tribunal and the Court of Appeal. So there were lots of issues in dispute at the level of the CAT, and I don't have time to discuss all of them, or even any of them completely. I just note, in light of Hugo's comments about standard of review just now, that to my eyes, this CAT judgment really exemplifies what merits review is about. It reads quite a lot like any first instance judgment that follows a full trial. And there's not really much that you can detect by way of deference in the CAT's analysis. And so while Royal Mail may not have liked the answer that it got in that it lost, it has certainly been told what the Tribunal thought about the evidence and issues in the case, rather than just being told that it was difficult and that Ofcom probably had it right. And what I really want to focus on, though, is the substantive issue that went to the Court of Appeal. And that was the question of what is the role of the as efficient competitor test, the AEC test, in exclusionary pricing abuse cases like this one. And as most of you probably know, the AEC test is a test that asks whether a downstream competitor could profitably compete with the dominant undertaking, given the access prices and the downstream prices charged by the dominant undertaking. So you look at the prices that the dominant undertaking is setting for its competitors to pay. You look at the prices that the dominant undertaking is itself charging, and you ask yourself the question, if the competitors had the same costs that were just as efficient as the dominant undertaking, could they operate profitably on the basis of those prices? And so in this case, what that would have meant was asking whether Royal Mail's new access prices would have allowed an equally efficient competitor to compete with Royal Mail in end-to-end delivery, or whether they would have excluded a competitor like that. And the issue came up because although Ofcom didn't rely on an AEC test, Royal Mail did. So that they put forward, by way of defense, effectively, their own AEC test, which they said showed that an equally efficient competitor could still have competed with Royal Mail on the basis of Royal Mail's new prices. And Ofcom and the Tribunal both considered that test, and they both said that on the facts of this case, the test was essentially not relevant. It didn't tell us anything interesting. And they had various reasons for that, and also various detailed criticisms of the modeling assumptions that were made in the test. But the key reason, at the bottom of it all, was that Royal Mail, as the dominant undertaking, had various advantages that derived from its position as a dominant undertaking. So there was never going to be an equally efficient competitor entering this market. And they also thought, and this was also key, that having a less efficient competitor enter the market was still better than nothing. So, simplifying things a little bit, essentially on that basis, they concluded that it was still anti-competitive for Royal Mail to deliberately design a scheme to exclude Whistle, even if that scheme wouldn't have excluded an equally efficient competitor. So Royal Mail appealed to the Court of Appeal on the basis that, as a matter of law, if it could show that its prices did not exclude equally efficient competitors, then they could not be abusive, or at least that it was very highly relevant to the question of whether their prices could be characterized as abusive. Now, there's lots of EU case law on the role of AEC tests, and I don't have time to go through it all, but there's a very good summary of it in the Court of Appeal's decision at paragraph 76 to 80 in the decision of Lord Justice Males. But the upshot of those decisions is essentially that in a margin squeeze case, where the allegation is about the gap between the access prices and the dominant company's downstream prices, as a general rule, an AEC test should be conducted using the dominant firm's own costs. So it's a proper AEC test. But there are exceptions. In other cases, however, the competition authority doesn't necessarily have to do an AEC test, although it might. If it does one, then it needs to do it right. And if the defendant puts forward an AEC test, then the case law is clear, and this is from Intel, that the competition authority and the courts have to consider it properly. But two questions arise from that. The first question is, how do we characterize the case at hand? How do we know if it's a margin squeeze case? Royal Mail said that this was, in effect, a margin squeeze case, but the tribunal said that actually it's very hard to say what kind of case it was. Is that a question of law, and how do we answer it? The second question is, in a case where the defendant does rely on an AEC test, and it shows that the pricing conduct could not exclude an AEC, in what circumstances is it still legitimate to find an abuse? It's clear that there are some circumstances, but what are they? And is that a legal question or an economic one? To my mind, those are really quite profound questions in that they effectively define what we mean by an abuse of dominant position. They tell us what normal competition or competition on the merits actually means. So the question is effectively, can a dominant company compete by setting whatever prices it wants, provided only that it will not exclude an equally efficient competitor? Or must the dominant company actually accommodate entry by inefficient competitors by offering them access prices that are low enough that even an inefficient competitor can still compete profitably? Now, the Court of Appeal says that those questions are not questions of law. Lord Justice Arnold gave the lead judgment, with which the other judges agreed. And at paragraph 64, he said that the question of whether the conduct was or wasn't like a margin squeeze was just a question of assessment. And so it fell within the tribunal's specialist expertise. And then in relation to the second question, which is about whether, if it's not a margin squeeze, you have to accommodate inefficient entry, Lord Justice Arnold said at paragraph 65 that the tribunal's assessment of whether the AEC test was relevant at all in this case was an assessment falling within the tribunal's specialist expertise again. And he said in the next paragraph that absent a submission that there was no evidence which entitled the tribunal to reach those conclusions, those assessments cannot be questioned in the Court of Appeal. Lord Justice Males made similar observations at paragraph 87. He said, competition law does not determine how much weight should be given to the AEC test. He said, that is a matter of judgment for the tribunal of fact, taking into account not only the robustness of the test itself, but all of the other circumstances which point either towards or against a finding of abuse. And he said, the Court of Appeal will not interfere unless it is shown that the judgment of the CAT is clearly wrong. Now, it's not obvious to me what is meant by clearly wrong, or how a tribunal of fact being clearly wrong about an economic assessment somehow converts that assessment into a question of law. But the general message that I think we can take from this is that the Court of Appeal is not at all keen to look at these issues at all. And that has, again, to my mind, quite profound implications for the application of competition law in this area. The tribunal summarized its reasons for finding that an AEC test was irrelevant in various places in the decision, but one of them is at paragraph 611, where it said that identification of an as efficient entrant was neither possible nor relevant, as entry by a less efficient competitor would also benefit competition and consumers. And that's fair enough. That's their expert view. I should also say that neither the Court of Appeal nor the Tribunal was trying to elevate that proposition to some kind of universal proposition of law that wherever it's satisfied, there will be an abuse if something happens to prevent entry. But at the same time, given that that's been upheld now on appeal, it's obviously available as a kind of formula for the Tribunal to adopt in other cases. In other words, it's clear that it's permissive in that the Tribunal can find in a particular case that it would be better than nothing to have less efficient competitors. And it can also find in those cases that there's no point in applying an AEC test. It just tells you nothing. The Tribunal doesn't have to reach that conclusion in any case, but it's something that it can say if it thinks it's right. But where that leaves us is that a bunch of really important questions are just questions of assessment to be made in all the circumstances. I mean, the first one is whether a less efficient competitor would be beneficial in the sense that improve competition and improve outcomes for consumers. That's obviously a question of economics, and it's obviously a question of assessment for the Tribunal. But then the next question is whether, because a less efficient competitor would be beneficial, the dominant undertaking has to accommodate that entry by setting prices that are either its own downstream prices or its upstream prices that are such that that inefficient entry can happen profitably. Now we're told that is also a question of assessment for the Tribunal, and we're also told that there are no legal standards at all to explain what the answer to that question should be. It is in effect an unstructured question of economics as to whether life would be better in all the circumstances if the dominant undertaking accommodated inefficient entry. Not only are all of those questions of assessment for the Tribunal, but in addition, if the Tribunal's answers to those questions is that the dominant company should accommodate entry, then there are also no legal standards to define how accommodating of entry the dominant company needs to be. How high or low should its prices be? Now, I don't want to be too alarmist about any of that, because we have to recall that the facts of this case were quite stark, and there was a strong finding of exclusionary intent. And there's nothing new about relying on exclusionary intent to find an abuse. But even where the court has done that before, like in AXO predatory pricing case, it's given us clear criteria that are based on prices and costs on the one hand and strategic intent on the other. Whereas the Court of Appeal in this case has left us with nothing. And so that means that there is in effect no review of this issue at the Court of Appeal level, and that there are also no legal principles to work with when advising dominant companies on their pricing conduct. So whatever you might think about the outcome of this particular case, that outcome strikes me as an unsatisfactory state of affairs. But I'm very interested to hear what others think about that when we get to questions at the end.
Daniel, you've raised fascinating questions. We could have a whole day or more on some of those points there. But in view of the time, I'm going to move straight on, if I may, to the talk by Marie Demetriou QC. Marie probably needs very little introduction. She's acknowledged to be a leading advocate in competition, regulatory, public law, and EU law. This year, she won both the Chambers and Partners Competition Silk of the Year and the Legal 500 EU and Competition Silk of the Year awards. She's on one of the 12 barristers named as one of the Hot 100 of 2020. And since 2015, she's been standing counsel to the CMA, and she seems to appear in virtually every major competition and regulatory case in the CAT and in all the other courts. Marie is going to touch on the instructive paroxetine litigation. Marie.
Thank you very much, Gerald. So I want to talk about paroxetine, first of all, because it was the judgment of the tribunal was handed down yesterday, so it's very current. And secondly, because there aren't actually that many CMA Article 102 decisions that proceed to appeal, and so this is one of them. And I'm sure the context of it is very familiar to most of you. The addressees of the Commission decision were GlaxoSmithKline, the manufacturer of Seroxat, an antidepressant, and various generic manufacturers. And there was an Article 102 part of the infringement and an Article 101 part of the infringement. Essentially, they related to agreements between GSK and the generic manufacturers, which settled patent litigation between them. So the generic manufacturers were challenging GSK's patents, saying that they weren't valid, and they were seeking to enter the market with a generic version of the drug, of Seroxat. And the agreements that GSK entered into with the generic companies settled the patent litigation, and the generic companies agreed not to enter into the market. And pursuant to the same agreements, GSK transferred both money and volumes of paroxetine to those companies for resale. And in short, the CMA found that those pay for delay agreements infringed Article 101 because they had the object and effect of restricting competition by staving off generic entry to the market, which would have led to a rapid reduction in the price of paroxetine, and also by enabling GSK and the generics to share the much higher profits associated with the branded drug. So that's the context. And the CMA in its decision, as well as finding infringements of Article 101, also found an infringement of Article 102 by GSK, essentially found that by entering into these agreements, GSK had infringed Article 102. And there were two issues on appeal in relation to Article 102. The first related to dominance. So GSK challenged the CMA's finding that it was dominant in the relevant market. And the second related to abuse. And really the abuse issues were very much the same as the restriction of competition issues under Article 101. And the CAT referred questions in relation to both of those issues to the European Court. And yesterday, in its judgment, the Tribunal applied the rulings from the European Court and found that the CMA had succeeded on both of those issues relating to Article 102 and indeed on the Article 101 issues too. And what I would like to do in the very short amount of time remaining is really to identify four lessons that can be learned really from this litigation. The first 2 points arose in the context of the market definition issue. And the first observation, the first lesson, is that the CMA can, at the appeal stage, support its decision by adducing expert economic evidence that it didn't rely on during the administrative procedure. Now, in short, the dominance issue here, the market definition issue, related to, so GSK on the one hand said that the relevant product market was all SSRI antidepressants because these were clinically substitutable for the others. And the CMA's case was that the relevant market was paroxetine. In this case, what the CMA did was supported its decision on market definition before the tribunal by relying on expert economic evidence from an external economist, Professor Carl Shapiro. And that evidence was adduced at the appeal stage and didn't form the basis for the decision itself. And in his evidence, essentially, Professor Shapiro explained why the CMA had been right to define the product market as being the market for paroxetine. So that's really the first observation that I wish to make. The second, and relatedly, because it relates to the same part of the Article 102 analysis, is that in certain circumstances, the CAT will uphold an infringement on a different basis to that set out in the CMA decision. Now, in this case, the CAT reached the same conclusion as the CMA on market definition, but held that it had done so for different reasons. Now, it's fair to point out that the CMA submitted that its reasoning was the same as the CAT's, but what matters here, of course, is the conclusion that the tribunal itself reached, and it found that its reasons for reaching the same conclusion were different to those of the CMA. And GSK, in its appeal, sought to persuade the tribunal to set aside that part of the decision on the basis that the tribunal disagreed with the CMA's reasoning. And the tribunal didn't do that. So the tribunal found that it was entitled to uphold the CMA's decision on other grounds, and so it did uphold the decision, but for its own reasons, and accordingly dismissed GSK's appeal against the finding of dominance. So that's the second observation. The third lesson I think can be learned from these proceedings is that hot-tubbing of expert evidence, hot-tubbing experts, is a flexible procedural tool that can be extremely effective. Now, I say it's flexible because in this case, there were three different buckets of economic evidence. So there was economic evidence relating to the question of market definition on the one hand. Secondly, there was expert economic evidence on the question of object and abuse. So were these agreements anti-competitive by their nature? And thirdly, there was economic evidence on pricing, which was much more granular. And the first two categories of evidence were hot-tubbed, and the pricing evidence was given sequentially and tested through cross-examination. So it's a good example of the flexibility of the procedure. And it's also a good example of how hot-tubbing can be effective. It was particularly effective on the market definition question. So there were two experts, Professor Shapiro, as I've said, for the CMA, and Dr. Stillman for GSK. The tribunal set an agenda of items for the experts to address, but actually during the course of the hot-tubbing, this was rather superseded by a free-flowing discussion between the two experts, in which the tribunal occasionally intervened to ask questions, and the experts listened to each other and responded to each other's views. And both at the hearing itself and in the judgment, the tribunal went out of its way to comment on how helpful the process had been. And in fact, it was telling that despite the fact that counsel for each side had the opportunity to do so afterwards, they chose not to supplement the discussion through cross-examination, because it really was a paradigm case of a hot tub enabling the tribunal to really drill down into the narrow area of disagreement between the two experts and get to the heart of the dispute. Now, the fourth and final observation I wish to make concerns the interaction between this appeal and proceedings brought by the European Commission, because the Commission had also been tackling pay for delay agreements and had issued decisions fining Lundbeck and 4 generic companies in respect of similar agreements concerning another antidepressant drug, citalopram. And those decisions had also been the subject of appeals in Luxembourg, which raised similar questions. And by the time of the trial in paroxetine, the General Court had ruled upholding the Commission decisions, but there were appeals pending before the CJU. And one of the reasons that the CAT gave for making a reference was that there were these pending appeals in the Lundbeck cases, which raised similar points. And so what happened was that the CMA intervened in the Lundbeck appeals before the CJU, and those appeals were heard by the same formation of the court, the fourth chamber, as heard the paroxetine reference, and by the same Advocate General, it was A.G. Cocotte in both cases. And so really it's an example of uniformity of EU law in action. And the observation I wish to make is this, that of course now post-Brexit, there's going to be much more scope for parallel Article 102 investigations by the Commission on the one hand and the CMA on the other hand. And we've seen that both the Commission and the CMA have clearly signalled their intentions to tackle big tech companies, for example. And now, of course, all potential abuses will have to be investigated separately by the CMA, separately to the Commission, in order that there be a remedy in the United Kingdom. But the status of Commission decisions and European Court judgments is now very different, of course, so they're only of persuasive value. And so in practice, what will that mean? Well, of course, unlike paroxetine, you can't have a reference to ensure uniformity. So if the CMA or the CAT wish to ensure uniformity with pending decisions in Brussels or Luxembourg, they would have to wait to see what those decisions say, but really query whether that is going to happen. So why would they wait for proceedings to unroll in Brussels and Luxembourg, given that those decisions will only be of persuasive value? So what we have, and I'll leave it here given the time, is a clear potential for divergence and a position where future cases, where there are parallel proceedings, are likely to be will be handled in a procedurally different way and may well give rise to divergent results. I think I'll leave it there in view of the time. Thank you very much for listening to us.
Well, thank you, Marie. I mean, those are 4 interesting and provoking observations, and the questions of new evidence on appeal, is obviously one which crops up frequently, and is in some contexts is quite contentious. Had there been time, I would love to have asked for the panel's views on the question whether, given the complexity which you highlighted and the interaction of economic assessment with law, there would be a need for certain types of pricing cases to be dealt with more after the event, as it were. In other words, look at the conduct first and then decide whether to prescribe it for the future, rather than to seek to decide whether something in the past has infringed and merits fines. Given the difficulty that the courts sometimes have, and that economists have, in deciding whether something is pro or anti-competitive. So anyway, there isn't time, sadly, to ask you to comment on that. We'll have to have another session sometime on all these questions. But I just want to thank you all for the work you put in on producing such interesting presentations in such a compressed period. They were really fascinating. And I also would like to thank Brick Court Chambers for hosting this session. And if I may just end on a parish pump notice to remind people, if on related subject, that on the 13th of May at 5:30 p.m, another star from Brick Court Chambers, Jemima Stratford QC, will be speaking on government intervention and regulatory disruption, recourse for business and investors. That's a webinar hosted by Brick Court with 3 Verulam buildings and Baker and Mackenzie, as I say, on the 13th of May at 5:30 p.m. So it just remains for me to apologize once more for disappearing from your screens, and to thank you for attending this webinar. And on that note, I will close